My brother said it with the kind of confidence that comes from never being questioned. He stood in the probate courtroom, adjusted the collar of his sport coat, and told the judge that I had never understood money, never paid attention to what mattered, and that our father had known this for years. He said I had floated through life while he, Dennis, had carried the family, while he had visited, while he had helped, while I had simply existed at a distance, absorbed in my own routines, useful to no one. I sat at the petitioner's table and did not respond. The judge, the Honorable Patricia Wren of Franklin County Probate Court in Columbus, Ohio, was a woman in her early 60s, with close-cropped gray hair and the measured stillness of someone who had presided over grief-soaked rooms for decades. She let Dennis's attorney finish his statement. Then she tilted her head, just slightly, and looked not at Dennis, but at his lawyer. "Counselor," she said quietly, "did your client provide you with a full occupational history for the co-petitioner?" Dennis's attorney, a younger man named Garrett Fulton, who had the polished confidence of someone accustomed to uncontested hearings, paused. "He works in accounting," he said. "Retired, I believe." Judge Wren looked at him for a moment longer than necessary. She said nothing. She simply picked up the case file and began reading something near the middle. Dennis glanced at me. I looked straight ahead. "My name is Arthur James Calloway. I am 63 years old. I spent 31 years as a forensic accountant for the Internal Revenue Service, the last 14 of those as a senior investigator specializing in estate fraud and financial exploitation of vulnerable adults. I retired 4 years ago, not because I was done, but because my father needed me closer." Dennis had not mentioned any of that. Garrett Fulton, apparently, had not thought to ask. My father, Walter Calloway, died 11 weeks before that hearing. He was 87. He had spent his final 2 years in a memory care facility in Westerville, where the staff knew him as the man who still tried to hum along to Frank Sinatra and who kept a worn leather notebook on his nightstand, even after reading had become difficult. He had been a machinist for 40 years, the kind of man who kept his tools organized by size and replaced worn handles before they broke. He had 3 grandchildren he called by the wrong names half the time and loved completely every moment. After my mother passed 12 years ago, my father had managed his affairs with quiet precision. He balanced his accounts monthly. He kept a fireproof box in the hall closet. He told me once, standing in the kitchen after her funeral, that he did not intend to be a burden and that the paperwork would be in order when the time came. Dennis had moved back to Columbus 8 years ago after a failed business venture in Phoenix left him starting over at 50. My father welcomed him without conditions. That was his nature. Within a year, Dennis was helping with groceries. Within 2, he had offered to handle the banking. Within 3, he had become the primary contact for my father's financial institutions, his insurance carrier, and the investment firm that managed the modest portfolio my father had built over 4 decades. I was living in Cincinnati at the time. I drove up most weekends. I called every evening. I sat with my father during appointments when I could and listened when he talked about the old neighborhood and the years before my mother's illness. He talked about those years often. Memory, near the end, doesn't retreat evenly. It leaves pockets. The probate hearing had been Dennis's idea, technically. After my father died, it had taken me less than 2 weeks to review the estate documents and recognize that things did not align. The will on file named Dennis as sole executor. A second document, a trust amendment signed 18 months before my father's death, had shifted the bulk of the estate into a revocable trust with Dennis as trustee and primary beneficiary. My portion had been reduced to a fixed sum. The family home in Bexley had been quietly transferred to an LLC the previous year, with Dennis as the registered agent. I had not been notified of any of these changes. My father during that period had been diagnosed with moderate stage Alzheimer's. When I raised concerns through a letter to Garrett Fulton's office, Dennis had moved preemptively. He filed a motion with the probate court asserting that I was attempting to contest the will out of financial self-interest and requesting that the court confirm the documents as valid and binding. He framed it as protecting our father's final wishes from a brother who had been mostly absent. I did not protest publicly. I did not call relatives. I did not post anything or speak to anyone outside of my attorney, Sarah Klein, who had practiced estate law in Columbus for 22 years and who asked questions the way a surgeon asks about symptoms, precisely, without hurry. Sarah had told me at our first meeting, let him file. Let him define the narrative first. People who believe they're in control stop watching for what they've missed. I had spent 3 decades watching for what people missed, I knew she was right. The courtroom was on the fourth floor of the Franklin County Courthouse, a room with tall windows that let in flat winter light and wooden benches that smelled faintly of lemon oil. There were no spectators. My daughter, Claire, sat 2 rows behind me. She had driven from Pittsburgh. She had not said much that morning. She had squeezed my shoulder in the hallway outside and said, "I know you, Dad." That was enough. Dennis sat across from me in a blazer and a pressed shirt. He had the posture of a man who had prepared his testimony carefully. He had also, I suspected, spent considerably more money on Garrett Fulton than the situation warranted, which told me he was nervous even if his expression said otherwise. When Judge Wren set down the file and looked at the room, something had shifted. The air carried a different quality, the way a room changes when someone who understands the actual stakes has finally read the room. "Mr. Calloway," she said, looking at me, "your attorney has submitted a preliminary filing. I've reviewed the summary." She paused. "I'd like to understand your professional background before we proceed." "In your own words." I stood. "I worked for the Internal Revenue Service for 31 years, I said, the last 14 as a senior forensic investigator. My work focused on estate fraud, financial exploitation of elderly adults, and the irregular movement of assets through instruments like trusts, LLCs, and power of attorney arrangements. I have testified in federal court on 17 occasions. I retired 4 years ago to spend more time with my father." The room was quiet. Judge Wren turned to Garrett Fulton. "Counselor," she said, "was this background part of your assessment when you advised your client to file this motion?" Garrett said nothing for a long moment. "My understanding was that he was a retired accountant, Your Honor." Judge Wren nodded slowly. She did not look amused. She looked like a woman recalibrating. "Very well," she said. "Miss Klein, you may begin." The first time my brother called me oblivious, I was 44 years old. We were standing in my father's backyard after Thanksgiving, the year my mother had started her first round of chemotherapy. Dennis had just driven in from Phoenix, arriving late, full of energy, trailing suggestions about treatment options he had read about online. I had been handling logistics for 3 months, appointments, insurance appeals, medication schedules, driving my father to and from radiation because he refused to stop driving himself until I convinced him otherwise. Dennis watched me refill the bird feeder near the porch and said, "You've always been like this, Art. Head down. You don't see the bigger picture." I didn't argue. I had learned early that arguing with Dennis was less productive than continuing to work. He moved loudly through the world, needed to be seen solving problems, needed credit to feel present. I had never needed that. My work required the opposite: invisibility, patience, the willingness to follow a thread for months before pulling it. What Dennis had never understood was that not reacting is not the same as not noticing. After my father's Alzheimer's diagnosis, I had started keeping my own records. Not because I suspected Dennis immediately. I had done it because that is what I do. Old habits don't dissolve with retirement. I tracked my father's account statements when I could access them. I noted inconsistencies. I documented dates of visits. I kept a simple spreadsheet, nothing official, just a habit. The first irregularity appeared 14 months before my father died. A transfer of $8,000 from my father's primary savings to an account I didn't recognize. I called the bank, identified myself, and was told the account was associated with a business entity. I wrote it down. Over the following months, I found 7 more transfers. Each was below the federal reporting threshold. Each occurred on a date when Dennis had visited the memory care facility. Each went to the same LLC. I did not confront Dennis. I did not call the bank. I requested copies of every document my father had signed in the preceding 3 years, through official channels, identifying myself and my relationship. Several came back with signatures that matched my father's handwriting, but were dated during documented periods of significant cognitive decline. His neurologist had noted in clinical records, which I obtained through a formal request, that my father had shown confusion, reduced comprehension, and impaired executive judgment during those precise windows. I photographed everything. Originals stayed where they were. It was during one of those visits to the memory care facility, 2 months before my father died, that I found the recorder. He had kept it in the drawer of his nightstand, tucked beneath a folded handkerchief and a photograph of my mother from 1971. It was a small handheld voice recorder, the kind that uses microcassettes, The kind people used in the 90s for dictation. My father had bought one when he first started forgetting things. He had used it the way he had once used his leather notebook to remember. There were 11 cassettes. I borrowed the recorder and brought it home. I sat at the kitchen table and listened to all of them over the course of a long evening. Most were ordinary: grocery lists, doctor's appointment times, notes about what to tell me on my next call, in the voice of a man trying to hold on to the shape of his own days. But 3 of the cassettes were different. The first was dated, verbally, by my father himself in a voice that was quieter than I remembered but still precise. Dennis came today. He asked me to sign something for the house. I asked him what it was. He said it would make things easier. I signed it. I shouldn't have. I was tired and I didn't read it carefully enough. I hope I didn't make a mistake. Don't tell Dennis I said this. I sat with that for a long time before pressing play again. The second cassette, recorded 2 weeks later. I've been thinking about the paper I signed. I looked in the box, but I can't find a copy. Dennis said he'd keep it somewhere safe. I don't know if that's right. Arthur would know. Arthur always knows about these things. I wish I'd called him first. My chest tightened in a way I hadn't expected. I had spent 30 years listening to recorded evidence and reading it with professional detachment. My father's voice would not allow that. The third cassette was the one I had to stop and restart. He had addressed it to me directly. He must have known I would find it eventually, or hoped I would. His voice was slower on this one, more deliberate. Art, if you're listening to this, I want you to know that I understood more than I let on. My mind goes in and out, but some things stay. I know Dennis has been handling things. I think he may have handled some things I didn't intend. I didn't want to cause trouble between you boys. You know how I am. But I kept these tapes because I know what you do. You understand paper. You understand when numbers don't add up. I'm trusting you to look at it and do what's right. Not for me. For what's right, that's all. I love you. Tell Claire she's my favorite. Don't tell the others. I sat on the floor of that kitchen for a long time. When I finally stood, I washed my face, poured a glass of water, and called Sarah Klein the next morning. Sarah did not react emotionally when I played her the recordings. She asked about the cassette dates, their provenance, the condition of the recorder. She asked whether my father had ever been recorded without his knowledge. I said no. She asked whether the voice was identifiable. I said unquestionably. Then she was quiet for a moment. This changes the burden, she said. Your father narrated his own uncertainty at the moment it occurred. That's not testimony, but it's context that matters enormously to a judge. She paused. The question is whether we introduce it before or after Dennis commits to his version of events. After, I said. Let him say what he's going to say. Then let my father respond to it. Sarah was quiet again. That's cold, she said, but she didn't mean it as a criticism. In the weeks before the hearing, I did 2 things proactively that the circumstances required. The first was to contact the Ohio Department of Aging's Adult Protective Services Unit directly. I provided them with the documentation I had gathered, the transfer records, the dates aligned with facility visits, the LLC registration, the signed documents, and their corresponding cognitive assessment windows. I did not ask them to act on my behalf. I provided information and let the process respond on its own terms. They opened a preliminary inquiry within 10 days. The second was to visit the memory care facility and speak with the director. My father had been a resident for 22 months. The staff knew his patterns well. I asked whether they had any documentation of Dennis's visits, whether any staff had witnessed my father signing documents on those dates, whether any concerns had been noted. The director pulled the visitor logs. 2 of the transfer dates corresponded to signed visits. One staff member recalled that my father had seemed confused and anxious on a date that matched one of the cassette recordings. She agreed to provide a written statement. I did not wait for someone else to gather this. My father had trusted me to look. I looked. By the time the hearing date arrived, the Adult Protective Services inquiry had been formally opened. A bank compliance officer had flagged the LLC transfers as part of a routine review triggered by the APS notification, and the Ohio Attorney General's Elder Justice Unit had requested documents from the LLC's registered agent, which was Dennis. None of this had been announced publicly. None of it was visible in the courtroom that morning, except perhaps in the way Judge Wren had looked at the case file before proceedings began. Sarah took her time at the petitioner's table. She did not pace. She placed both hands flat and spoke clearly. the way people speak when they are not performing confidence, but simply habit. Your Honor, she began, this petition claims that the estate documents reflect the genuine wishes of Walter Calloway. What we intend to show is that those documents were executed during periods of documented cognitive vulnerability, without independent legal counsel for the decedent, and that the assets transferred through those instruments do not correspond to any expression of intent Mr. Calloway made while he retained full capacity. Garrett objected almost immediately. Sustained foundation, he said. Judge Wren looked at him. Overruled. Proceed. Sarah started with the neurological records. She did not claim my father had been incompetent. She framed it clinically and carefully. The document transferring the family home to the LLC was signed on a date when my father's neurologist had noted in clinical records that he showed impaired judgment and reduced executive functioning. The trust amendment reducing Arthur Calloway's share was signed 6 days after a documented period of acute confusion. In Ohio, she said, capacity is evaluated at the moment of execution. Vulnerability during that window requires scrutiny, particularly when the benefiting party was present and no independent counsel was engaged. Garrett objected again. This time his voice had less certainty in it. Judge Wren overruled him without looking up. Sarah moved to the transfers. She presented the spreadsheet. Not my version. A formally prepared exhibit from a CPA Sarah had engaged to review the records. 8 transfers over 14 months. Total amount, $64,000. All routed to an LLC for which Dennis was the sole officer. No corresponding invoices, no documented services rendered, no record of any agreement between Walter Calloway and that entity. Then Dennis stood. He did not wait for Garrett. He said, my father trusted me. He asked me to manage these things because Art was never around. He lived 2 hours away. He came on weekends when it was convenient. I was here. I handled the hard parts. Judge Wren raised one hand. Mr. Calloway, she said, you are represented by counsel. Please be seated. Dennis sat down slowly. His jaw was tight. Judge Wren looked at Sarah. Miss Klein, is there additional evidence you wish to introduce? Sarah said yes. She had saved it deliberately. She did not describe the cassettes dramatically. She simply explained what they were, how they had been found, by whom, under what circumstances. She submitted them as exhibits. She requested that a brief portion be played aloud for the court. Garrett objected on hearsay grounds. Judge Wren considered this for a moment. A recorded statement made by the decedent contemporaneously with the events in question, she said, falls within exceptions the court recognizes for state of mind and verbal acts. Overruled. The recording played in courtroom 4B of the Franklin County Courthouse. My father's voice filled the room, slower than I remembered from my childhood, but unmistakably his. Dennis came today. He asked me to sign something for the house. I asked him what it was. He said it would make things easier. I signed it. I shouldn't have. The room was very still. When the recording ended, Judge Wren did not look at Dennis. She looked at the window, then she looked back at the file. Dennis broke the quiet. That recording could have been made any time, he said sharply. Dad got confused. He didn't know what he was saying half the time. That doesn't prove anything. Mr. Calloway, Judge Wren said. Final warning? She turned to Garrett. Counselor, she said, does your client wish to provide any documentation showing independent legal counsel was present when Walter Calloway executed these instruments? Garrett paused too long before answering. Not at this time, Your Honor. Judge Wren folded her hands. She looked at the room in the way I had learned to recognize after a long career, sitting across tables from people who thought they had constructed something airtight. It was the look of someone who had seen the seams. I am suspending these estate documents pending further review, she said. The transfers in question are hereby frozen, pending a full accounting. I am requesting that Adult Protective Services submit their preliminary findings to this court within 30 days. She paused. I am also referring this matter to the Franklin County District Attorney's Office for review under Ohio's financial exploitation statute. She looked at Dennis one final time. Mr. Calloway, she said, your brother did not contest these documents out of financial self-interest. He did so because he understood exactly what he was looking at. That distinction matters. She struck the gavel. The sound was unremarkable. It landed the way true things land. Outside the courtroom, Claire hugged me in the corridor without saying anything. Sarah stood a few feet away, giving us space. When Claire finally stepped back, her eyes were red, but her expression was steady. "Grandpa knew you'd figure it out," she said. I nodded. I didn't trust my voice just then. Dennis did not speak to me that day, or for several weeks after. His attorney withdrew 60 days into the district attorney's review. He retained new counsel. The process that followed was what these processes always are: slow, documented, procedural. It did not move with the speed of a story. It moved with the weight of evidence. APS completed their formal assessment and submitted findings to the court that described a pattern consistent with financial exploitation of a vulnerable adult. The Ohio AG's Elder Justice Unit continued its review of the LLC. The bank compliance inquiry widened to include accounts Dennis had access to through a joint account established 3 years before my father's death. Dennis was charged 4 months after the hearing. The indictment listed counts under Ohio Revised Code 2913.02, theft from an elderly person, and 2913.31, forgery, related to documents signed during periods of documented incapacity. The charges were not the maximum available under the statute. They were enough to anchor what came next. Plea negotiations took longer than the district attorney had initially expected. Dennis rejected the first offer. He rejected the second. His attorney made arguments about good intent, about the complexity of caregiving, about how my father had always meant to take care of Dennis in ways he hadn't gotten around to formalizing. Each argument ran against the transfers, against the LLC, against the recordings, against the fact that my father had narrated his own confusion on microcassette in the drawer of his nightstand. Dennis accepted a plea to a felony theft charge 10 months after the hearing. The sentence reflected the court's recognition that there was no prior record and that partial restitution had been offered during negotiations. 3 years probation, full restitution with interest, a requirement to dissolve the LLC and return all assets improperly transferred, a permanent prohibition from acting as executor, trustee, or financial agent for any other person. The family home in Bexley was returned to the estate. It sold in the spring. The proceeds, along with the restored investment accounts, were distributed according to my father's original will, the one he had signed 12 years earlier with my mother still living and his mind fully intact. My share came to more than I had expected. I didn't spend much time thinking about it. Money, at the end of something like this, doesn't feel like winning. It feels like correction. The harder parts were the ones that didn't appear in any court filing. My brother's daughter, my niece, stopped calling for almost a year. When she finally reached out, it was a text. Short, careful, written the way people write when they're testing whether the ground will hold. I responded. We spoke a few weeks later. She cried. She said she had known something was wrong for a long time and had told herself it wasn't her business. I said, "It's over now. What comes next is up to us." That's where we are, building something careful. Claire and I drove to Bexley the morning the house sold. We parked on the street and sat there in the gray March light, looking at the front porch, the old maple my father had planted the year I was born, the window to the kitchen where he had drunk his coffee every morning and kept his notebook open beside the mug. "I want to do something," Claire said, "but I don't know what." "I know," I said. We sat there a while longer. Then I took the recorder from the bag I'd brought, the original, with all 11 cassettes still inside. I had made copies. The originals had served their purpose. I thought about keeping it, but keeping it felt like holding the wrong thing. My father had not meant it as a keepsake. He had meant it as a tool. I set it on the porch railing where the new owners would find it. Maybe they'd throw it away. Maybe someone would wonder what it was. It didn't matter. What mattered was that it had done what he had asked it to do. I looked at that porch for a long moment. Then I got in the car. There are things that restore themselves after something like this, and things that don't. My relationship with my daughter deepened in a way I hadn't anticipated. My employer, a consulting firm I had joined after retiring from the IRS, handled the period of legal involvement with professionalism and reinstated me to full capacity without comment after the proceedings concluded. That steadiness mattered. What didn't fully restore was the version of my brother I had known before. Not because I couldn't forgive the act. I understood professionally and personally how these things begin incremental, justified, ordinary feeling until they aren't. What I couldn't reclaim was the belief that we had ever seen each other clearly. I had overestimated his restraint. He had underestimated my attention. We had both been wrong about the other for a long time. We spoke once, briefly, after the sentencing. He said I had made my point. I told him I hadn't been making a point. He didn't respond. Maybe one day we'll find something smaller to stand on. I'm not in a hurry. What I think about most, when this period comes back to me, is my father's voice on that cassette. Not the legal weight of it, not the way it shifted the hearing, just the voice itself, the deliberateness of it. A man who had spent his whole life trusting people quietly, who had made one late, clear decision to trust me specifically, to leave a trail he knew I would follow. He had not raised his voice. He had not accused. He had recorded his uncertainty on small magnetic tape and placed it where I would eventually look, because he had known, even when his memory was failing, that I was the kind of person who looks carefully. He had told me that once, years ago, on the porch of that house. "You don't make a lot of noise, Art," he had said, "but you don't miss much either." I had not said anything at the time. I just sat with him and watched the street. That, too, was enough. If you've stayed with this story through its difficult middle, I'd like to know where you're watching from. Leave a comment. Tell me what time it is there. These aren't stories about triumph. They're stories about what holds when things break. And if that's the kind of story that means something to you, there are more ahead. I'd be honored to share them.